Hi, have you ever thought about buying a pre-construction house or condo from a builder? Have you ever wondered what the risks are or other important details that you really should consider? I'm Michael Shuster, multi-award winning real estate specialist in the Greater Toronto Area and the surrounding suburbs. People are increasingly enticed these days with the idea of buying pre-construction condos or pre-construction houses from a builder. Now perhaps they like the idea of buying a property that is new, modern, and never been lived in, or a property with a warranty. And for some who are thinking investment, they might have heard that they can buy a property that will most likely appreciate in value before they actually have to close the deal or close the purchase, or by the time it's ready for occupancy. Of course, there are pros and cons to everything, which is why getting all the facts before you take action is always important. What might be a great idea for someone else might be a bad idea for you, or vice versa. Buying a pre-construction property is very, very different than buying a resale property. There are additional risks and surprises that can come along with buying a pre-construction property from a builder. Today I'm going to share some of the risks that buyers might face when dealing with a builder's agreement of purchase and sale for a pre-construction property, which is different than a typical agreement of purchase and sale that realtors use when they facilitate the sale of resale properties. Number one, a typical builder's agreement of purchase and sale is very, very long, complicated, and a very in-depth agreement, which is prepared by the builder's lawyers. Unlike a typical agreement of purchase and sale realtors use for resale properties, the builder's agreement of purchase and sale is much longer, more detailed, and comprehensive, which is a good thing if it protects you, the buyer. But given that it's prepared by the builder's lawyer, it is usually looking out for the best interests of the builder. It's often so detailed and onerous that you definitely need a lawyer of your own just to review it. The builder's agreement often contains many provisions which are one-sided in favor of the builder. When buying a pre-construction condo, a buyer will have a 10-day rescission or cooling off period to cancel the transaction if you're not satisfied with the terms of the contract. Now during this period, I always recommend the buyers contact an experienced real estate lawyer to review the contract and provide legal advice. Number two, different from a typical agreement of purchase and sale that realtors ordinarily use, a builder's agreement has a section on adjustments. Now these are the costs that buyers will have to pay for items like development charges, lot levies, carry-on enrollment fees, utility connection fees, and other fees that you wouldn't ordinarily have tacked on to your purchase if you were buying resale. The cost of these adjustments can also increase the purchase price by thousands of dollars. In some cases, the builder will provide caps for the adjustment costs, and sometimes they won't. Either way, you need your lawyer to review the adjustments with you so you'll be aware of how much extra money you're going to need on closing to pay for these items. Number three, many buyers are dazzled by glossy brochures and plans at the sales office. Unfortunately, what you see is not always what you get. This is because a typical builder's agreement gives the builder the right to alter the plans and the dimensions and substitute materials without the requirement to provide any compensation to the buyer. Number four, many buyers don't realize that the builder determines when the property is complete and fit for living and moving into. The builder sets the closing date and the buyer has no say in the matter. In some cases, very little notice is provided, leaving the buyer to scramble to arrange for financing and moving and other sorts of things. A buyer will be forced to close the deal, pay for and move into the property that may be unfinished completely, while the buyer will have an opportunity to do a pre-delivery inspection prior to closing. Unfinished items are completed by the builder after closing, subject to the builder's schedule and availability of trades. So in other words, if you were buying something, you normally wouldn't pay for it until you get it in its entirety, until it's complete. But builders can insist on a closing date, even though it's not complete, make you pay in full, and then say they're coming back to fix things afterwards. Number five, the builder has very liberal rights to extend the closing date for a number of reasons. The occupancy date on the agreement of purchase and sale is tentative and should not be relied upon as the final date. The date can and will likely change, and while delayed occupancy compensation might be available, there is a limit to the amount that they're required to give you as compensation. Number 6, alternatively, the buyer has no rights to extend the closing date. So if a buyer is unable to arrange financing in time for closing, the buyer cannot insist on extending the closing date. So remember, you put down a deposit, sometimes 2 or 3 years before completion, and lenders won't, mortgage brokers and banks, won't pre-qualify or pre-approve for a real estate purchase that many years in advance. Your employment or your financial situation might have changed in that time. When you know your closing date is firm, you have to apply for a mortgage and go through the approval process and arrange for all of that within a few months before closing date. The builder does not have to grant you an extension if you need an extension to get your financing. If they do, they can charge extension fees, which can amount to thousands of dollars in some cases, depending on the builder. Number 7, some people think they will just put down a deposit, hope the property goes up in value during the 2 or 3 years of construction, and then they'll sell it, theoretically on paper, to another buyer before the deal actually closes. In other words, an assignment. That way, they make a profit without actually having to get a mortgage and having to close the deal. It's called an assignment, and some builders don't allow assignments if you read the fine print. Other builders will allow assignments, but you first need their consent, which might be arbitrarily withheld by the builder. In other words, there's no guarantee that the builder will let you assign it. They might force you to close the deal or forfeit. And if they do, there are often conditions and assignment fees that must be paid. Number 8, sometimes a buyer needs to add a third party to the agreement of purchase and sale because they may not qualify for financing, so they need a co-signer, for example. A buyer cannot unilaterally add a third party to an agreement of purchase and sale by a builder. The consent of the builder must be obtained once again, and the builder might charge a fee for this. Number 9, many buyers who buy a property for purely investment purposes do not understand how the HST applies to the purchase of a new property. If the buyer or its immediate family members will not be living in the property as the primary residence, then the buyer will not qualify for the HST rebate, which means the builder will charge the buyer the HST on closing. This could add on an additional $25,000 or more to the purchase price. Also, builders are now getting very stringent on this point and have the ability to charge buyers the HST rebate if they suspect the buyers being untruthful about moving into the property. And number 10, many buyers don't realize that a builder's agreement of purchase and sale may allow the builder to cancel the contract altogether for a number of reasons. For example, the builder can cancel the contract if it fails to sell a certain number of units, if it fails to get bank financing for construction, or if it fails to obtain the necessary approvals from the municipality. Finally, although it is rare, the builder may go bankrupt, leaving a buyer's deposit at risk. Even if some of your deposit is protected by TheREguy, remember that TheREguy only provides a limit on the amount of deposit protection that is available. So if you want to know more about buying resale or pre-construction and how to do it safely and smoothly, I'm always happy to chat. And remember, when it comes to real estate or anything else in life, if there was a better way, wouldn't you at least want to know about it? Just email me with any questions that you have, mike@TheREguy.ca. It's always confidential. There's never any pressure or obligations. I just love to help and I love to talk real estate. Thanks for watching.